we're ready. Okay. Yeah. Be just a few more seconds. Oh, yay. Oh, yay. Oh, yay. The Honorable Supreme Court of Arkansas is now in session. All persons having business before this honorable court, draw near, give attention, and you shall be heard. May God save these United States, the state of Arkansas, and this honorable court.
Good morning. We have cases to hand down this morning. CV-20-164, Billy Wolf versus Dexter Payne, Director of Arkansas Department of Correction, from Jefferson County Circuit Court. Affirmed. Justice Webb dissents.
CR 11-613, Danny Lee Ashley versus State of Arkansas, from Grant County Circuit Court. Petitioner's pro se petition to reinvest jurisdiction in the trial court to consider a petition for writ of error quorum nobis and for clarification of certain dates. Petition denied.
So Justice Webb, you're still on mute.
Thank you. Larry Walther, Cabinet Secretary, Arkansas Department of Finance and Administration versus Wellspun Tubular LLC. Circuit Court affirmed.
And will the clerk please read the submissions?
There are a total of 10 cases being submitted to the court today, the first two of which will be a combined oral argument. Civil Case 20-164, Michael McCarty and others versus the Arkansas State Plant Board will be combined with Civil Case 21-73, Monsanto Company versus the Arkansas State Plant Board. These are two separate appeals being heard in one oral argument today. Both appeals are from Pulaski Circuit. In addition to those two being submitted today, we have Criminal Case 20-232, Montrell Ventry versus the state from Saline Circuit. Civil Case 20-637, Robert Steinbuck versus the University of Arkansas and others from Pulaski Circuit. Criminal 19-421, Robert Woodward versus the state from Chico Circuit. Criminal 20-176, Rodney W. Rayburn versus the state from Cleburne Circuit. Criminal 20-553, Gerald Lowry versus the state from Miller Circuit. Criminal 20-599, Stephen C. Hayes versus the state from Saline Circuit. Criminal 20-640, Randy James Myers versus the state from Faulkner Circuit. And finally, Civil Case 20-288, Larry Osborne versus Dexter Payne as the Director of the Department of Correction, an appeal from Jefferson Circuit. In addition to these 10 cases that are being submitted to the court, there are 7 other various motions and petitions. All the submissions and all of today's decisions are available on the court's website.
Okay, thank you. Our oral argument today will be the combined oral argument for 2 cases as mentioned. Civil 20-164, McCarty versus Arkansas Plant Board, and Civil 20-173, Monsanto versus Arkansas State Plant Board. I understand that counsel for the McCarty appellants will argue first. Mr. Ballard, the court will recognize you for your argument.
Thank you, Chief Judge. May it please the court. My name is Grant Ballard, and I represent, along with David Gerstner, the appellants in this matter. Those are Michael McCarty Perry Galloway, Matt Smith, Greg Hart, Ross Bell, and Beckton Bell. I'll reserve 5 minutes of my time for rebuttal. For the court's information and background, the appellants in this case are Arkansas farmers regulated by the Arkansas State Plant Board. And they have taken up the cause of challenging the manner in which the members of this state agency, the State Plant Board, are appointed. That appointment process is codified at Arkansas Code Annotated 216-206A, and we have challenged formally the General Assembly's grant of public appointment power to private business interests. And the issue for the court is quite simple. Can the Arkansas General Assembly delegate its public appointment power to private business associations? In this situation, you have a scheme where the General Assembly has given private business associations direct power to appoint the members of a state agency, a rulemaking state agency, which also is tasked with enforcing the rules it creates. So by delegating the power, I would suggest to the court, by delegating the appointment power, the people have no voice in the process. The regulated citizenry has no voice in the process by which the individuals are appointed to the state agency. And in effect, the public is out of the sphere of influence and does not know the process by which individuals are appointed to a state agency. The question for the court now is whether this arrangement violates our state constitution. And I believe the fundamental principle embodied in Article 5 of the state constitution, that our people are to be governed by their elected representatives. I don't think there's any genuine dispute in this case that there has been a delegation of public appointment power. I think that is conceded on all sides. I think the question becomes whether or not that is constitutional. And in my review of cases across the country where courts have been asked to decide whether or not a delegation of legislative authority is constitutional, that hinges on two questions or two things. The first is, what does the state constitution say? And the second hoop to jump through, so to speak, is what is the specific appointment process? So what does the Arkansas Constitution say? Real briefly, I'll point out that the Arkansas Constitution in Article 2 says all political power is inherent in the people. And the people, only the people, have the right to reform and alter the political power.
Mr. Ballard, if I may, before we get into the merits of that argument, I just wanted to go back to a motion that we recently took up about granting judicial notice of Act 361. And I'm wondering if the presence of Act 361, what kind of effect does that have on your claim here? Does it moot anything, or do we just proceed as normal, pretending that the legislature doesn't have this in play?
Judge, that's a great question. I believe the answer is that Act 361 did not moot the controversy. And I've got two primary reasons that I suggest that to you. The first is we still have members on the state plant board that were appointed under the present statute. They're appointed directly by private business associations. And Act 361 specifically provides that those directly appointed members will continue to serve on the board. So Act 361 does not cure the problem that we have individuals exercising public power that was given to them by private business association. So,
Counselor, does Act 361, is that a kind of an embodiment of our legislature kind of retroactively blessing or curing the process that you are alleging is faulty?
I don't believe that Act 361 can cure the exercise of unconstitutional power that has happened in the past. For example, the plant board is now enforcing regulations that were created by an unconstitutionally appointed board. there were unconstitutional acts, and there are rules in place now that were established by a board that was appointed by private business interests. And I don't think Act 361 will retroactively cure that problem. I think that the fact that the board continues to enforce rules that were promulgated by individuals that are no longer on the board, that were appointed directly by private business interests, is a real question. And I would suggest to you, Judge, that it's likely that if the court does not rule on the constitutionality of this statute, this issue, the question of the constitutionality of 216-206A, as it presently stands, will come back to the court, because the plant board is in fact pursuing enforcement cases against farmers they allege violated, for example, the April 15th, 2018 cutoff date. And some of the defenses that have been raised in those cases are that the statute was unconstitutional at that time. So I think that I don't think that the issue's moot. I think it's live. And I think if the court doesn't address it now, the court will eventually have to address whether or not the present form of the statute is constitutional.
Counsel, on that point, how does the de facto officer doctrine play in if the concern is that these people were unconstitutionally appointed to the board and the board was not properly made up? How do we address that with the de facto officer doctrine to determine whether or not their actions that they've taken are valid?
I don't think that the de facto officer doctrine is applicable in this case, because it's not a collateral challenge. I think all the Arkansas case law says is that if you want to challenge a rule, you just have to make a direct attack. This is not a collateral challenge. I'd also point out, I think the United States Supreme Court has made clear that the de facto officer doctrine is intended for technical issues rather than constitutional infirmities in the appointment process. I think that's Ryder v. United States. So I just don't think the de facto officer doctrine is applicable in this case, given the case law that I've reviewed and it's been briefed to the court.
Well, the implications of a plant board being in existence for a number of years and all of the acts that would have occurred during that time, are all of those going to be in question as well if we don't believe that the de facto authority here would somehow cover these inequities?
I think that the acts are only in question as they are challenged, Judge, and I don't believe that you'd have a wild west kind of situation, because pesticide use, for example, is very heavily regulated. And we've got federal regulations and federal labels on the use of pesticides, and the plant board can still enforce the federal rules, which are the base of the regulations of pesticides in this country. So I don't think
how would they enforce them under your theory that they're not constitutionally enabled to act?
I think that the plant
Even if
board,
it's not an Arkansas rule, you're arguing that they can't do anything because they're not constitutionally appointed.
I think that the plant board, for example, would have to refer violations to the EPA for enforcement under the Federal Pesticide Control Act.
Counsel, if the new act is at issue, I know you have constitutional issues with it, but even the appointment process under that, it doesn't go into effect, I believe, probably till August 1st or sometime in there. If this court found it was unconstitutional, what remedy are you seeking? Or would we be vacating those positions? And if so, what happens if there's not really a majority members of the board until the new act takes effect, even if you disagree whether it's constitutional?
Well, that's a great question. I think the General Assembly has to act to fill those positions. The relief we are requesting is that the constitutional delegation of appointment power per the statute is unconstitutional, and that it's a live issue. And I think that the positions appointed by private interest should be declared as void, and that's our position.
Well, counsel, we said it was a live issue, obviously, in our previous order. Is the only thing that's changed since then is the fact that the legislature has acted even though the act isn't in effect.
I believe that is the only change. And I would also suggest, a review of the case law. I'm not so sure that the amended statute is constitutional, because it seems to take from the discretion of the governor the identity of the appointees. And I see that my time's running low, so I will save remaining time for rebuttal. Thank you.
Mr. Ballard, let me ask a question after I ask it, and that is, assuming we agree with your argument that the appointments are unconstitutional, and this is to follow up on what Justice Wood is asking you, then are you suggesting that we remand this to the circuit court for further proceedings, or are you asking us to do something else?
I'm asking you, Judge, to make a determination that those positions that were appointed by private business associations were basically void, and they were without constitutional authority and effect.
And as a result of that, then what are you asking? I mean, if we remanded the circuit court to follow our direction, then what would you be asking the circuit court to do?
Well, I think it's on a case-by-case basis, because we've got certain regulations that are being enforced now that were implemented by a board. And the question would become on a case-by-case basis whether or not there were enough votes with constitutional authority to pass those regulations.
And counsel, but if, let's say, and we're just, your time is stopped, so it doesn't count against it, if that's what your concern is. But if let's say that the positions are vacated, again, we don't have even a quorum on the Arkansas Plant Board, so no further regulations could go into effect. So even ones that are out for public comment could not proceed until, I guess, the legislature would have to open session back up to act. Is that what your answer was earlier to me?
That is correct. I think the General Assembly would have to take action.
Okay, thank you.
Thank you.
So counsel, to Justice Hudson's earlier point, I think the response you just gave to Justice Wynn may be somewhat in conflict with your earlier response. If we find that these members have not been constitutionally appointed, and if we don't apply the de facto officer doctrine, then anything they've done is invalid. So it does, I realize we're dealing just with the issues that on the actions they've taken in your case that's before us now, but that does open the door to what you described as kind of that Wild West scenario, or it takes all similar enforcements and puts it into the hands of the EPA or some other agency.
Well, Justice, I would suggest that, if you rule the statute is unconstitutional and the appointments were invalid, that it only goes to those members of the board that were in fact appointed by private business interests. And I think that you would not have the Wild West scenario, because in the example of pesticides, which brings us here today, they're so heavily regulated on the federal level.
But the reality is the plant board has a reach that's far greater in terms of the issues that they deal with than just pesticides. Isn't that true?
That is true.
So Mr. Ballard, if we determine that the appointees that you're talking about are unconstitutional, would that reduce the number of plant board members required for a quorum?
I don't believe so, Justice Wynn, because the number of members is established by statute as well.
Okay.
So then how does your last response to me have any effect to the board being able to act with the remaining members? Because as Justice Wood pointed out, you would lack a quorum if the challenged members are removed.
That may very well be so.
Any more questions? Thank you, Mr. Ballard.
Thank you.
Court will recognize Ms. Blackwell, counsel for Monsanto.
Thank you, and may it please the court. Liz Blackwell on behalf of the appellant and cross appellee Monsanto Company. I'd like to reserve 4 minutes of my time for rebuttal. Unlike the trial court in Mr. Ballard's case, the trial court in Monsanto's case correctly held that the statute governing appointments to the plant board is unconstitutional. That ruling is challenged on cross appeal, and so I will address it as well. But the issue for direct appeal is actually Monsanto's challenge to a regulation that was adopted by that unconstitutionally appointed board. Where government power is conferred on agency officials, not by the people, but by private organizations, you risk a regulatory system that doesn't serve the public interest, but actually serves only the interests of those private organizations. And that's why we're here today. In 2016, after nearly 7 years of considering the relevant scientific research and data submitted, the U.S. Environmental Protection Agency granted a federal registration for a new pesticide developed by Monsanto called XtendiMax. That development was heralded as a major success and advancement for farmers, and every soybean and cotton growing state in the country approved the use of XtendiMax in 2017, except for Arkansas. In Arkansas, the state plant board, comprised primarily of individuals appointed by private interest, voted not to allow the use of the new herbicide in Arkansas and to deprive Arkansas farmers of this new effective tool.
Ms.
The board
Blackwell,
justified.
Ms. Blackwell,
Yes.
if I might, so in Arkansas, we are a fact pleading state. And I've been studying your second amended complaint that is at issue here and that Judge Piazza dealt with in his rulings. My question is, it's going to justiciability, whether or not we have a live case and controversy at play here. And I'm wondering what practical effect our decision would have upon a controversy. And what I would like for you to tell me is, what are the facts at play that in regards to Regulation 7 and Monsanto, how your client is being affected by this regulation? What is the problem? Where does the rubber hit the road here?
Certainly. So because Regulation 7 grants primacy to pesticide research that's conducted by researchers at universities in the state of Arkansas, that impacts not just Monsanto, but all pesticide registrants' decision-making in terms of where to spend their research dollars. And so if the regulation says the primary authority that we're going to look at, or the primary data we're going to consider for purposes of making our pesticide registration decisions, is going to be research conducted by those scientists who work at universities in the state, where are pesticide registrants going to be funneling their research dollars? They're certainly going to.
As you know, Regulation 7 doesn't limit the evaluation to the research coming out of Arkansas. It also specifically says the board may consider other research sources and is not bound by the advice or finding of any one individual or entity.
Yes, and the U.S. Supreme Court has held that state laws or state regulations that incentivize or pressure companies to increase their in-state operations or economic activity.
And I guess maybe I'm leading you down the wrong road. I want to back up more towards to the facts that are at play under Regulation 7 with Monsanto. What is the problem here? Are there some facts? I'm wondering if there's some facts that I haven't found or have overlooked in the record, whereby possibly Monsanto has gone to the plant board and said, would you please reconsider your decision, or that there's been some new ask of the plant board in regard to a product, possibly XtendiMax. Can you help bring me up to speed on that?
Sure. I'm sorry if I misunderstood the question.
Oh, no.
Yes. Every year since 2016, 2017, the plant board has been asked to consider requests to allow farmers in Arkansas to use XtendiMax in accordance with the federal registration, so the federal label from EPA. And in fact, the plant board, I think it's on May 11th, is going to again consider whether or not to allow farmers in Arkansas to use XtendiMax according to the federal label. So it's very much a live issue.
You're saying it's an annual decision that the plant board makes?
Well, every year farmers or Monsanto have petitioned the board to change its stance and allow farmers to use the product in accordance with its federal label. And every year the board has said, no, that issue is coming before the board again in May of this year. So it's very much a live issue. There's an application of Regulation 7 every time the board looks at whether or not it's going to allow Arkansas farmers to just use the product the way the EPA says it should be used.
Okay, what I'm going to ask you next is if you will point into the second amended complaint where those facts are pled, because Arkansas is a fact pleading state. And I'll be honest with you, my struggle is that when I review that complaint, I see references by Monsanto to the unwritten rule. And you know that we took up contemplations about the unwritten rule in our 2019 decision. So if you could help square me up on that, I'd appreciate it.
Well, so Regulation 7, the codified version of Regulation 7, not the unwritten rule, is specifically referenced in the second amended complaint.
It is referenced, but I need to know where the fact allied with Regulation 7 for Monsanto.
Yes. So I would say, if we could back up just for a second, clearly there is a constitutional Commerce Clause challenge to the statute on its face. And the statute or the regulation continues to apply. It's a live regulation. And so what the Supreme Court has said is, with respect to Commerce Clause challenges, it's really just a legal question, not a factual question or a factual dispute. If there is a state law that is impacting and discriminating against interstate commerce, you just analyze that on the face of the regulation. And so whether or not
that is confusing to me, because when I look to our case law, and I think this is actually a case that Justice Wood authored back in 2017, Rogers versus Knight, we say a case is not justiciable when any judgment rendered would have no practical legal effect upon a then existing legal controversy. So what is the legal controversy at hand that our decision would have a practical effect upon?
Well, that pesticide registrants continue to have their decisions regarding whom to retain to perform research for them. And as I said, going forward, the application of Regulation 7 and its preference for in-state research, all of that continues to have an impact every day. Every day, pesticide registrants are deciding who they're going to hire to do the research that they'll use to support registrations, and Regulation 7 impacts that. And the Commerce Clause says if you have a regulation that is, in fact, on its face, discriminating between in-state and out-of-state economic interests, then you have to satisfy the requirements in the case law under the Commerce Clause.
So we would skip over the fact pleading requirements in our state if we're dealing with the Commerce Clause question, because it's legal. Is that what you're saying?
Essentially, although there are facts pled clearly in the complaint about Regulation 7 and its impact, but yes.
Please point me to the paragraphs in the complaint, because
if I could do that on rebuttal, the thing that we've said in the complaint, and I think I have it here and I can look at it, is that this regulation continues to influence registrants in terms of how they can decide to spend their research dollars.
Certainly. I mean, a regulation is going to affect anyone in the universe who is in front of the plant board, but that doesn't mean that it's a justiciable issue.
Okay. I'll come back to that on rebuttal. But as I said, Your Honor, I think the issue for the Commerce Clause challenges is just a facial challenge. We're arguing that on its face, it discriminates between in-state and out-of-state interests. And under Supreme Court precedent, where that is the case, the statute or the regulation is valid only if the state can show that there's no other way that the state can promote its legitimate interests. And so here,
roll into Arkansas and challenge this. You don't have to have standing, or it would just anybody.
I don't think it eliminates standing requirements, Your Honor. I think if you are someone affected by the regulation, as Monsanto clearly is, in that case, you would have standing.
Counsel, how do you, can you tell us, how do you have standing with regards to Regulation 7 currently? So currently, what is your, how is Regulation 7 impacting you and the specific product XtendiMax as you pled in the second amended complaint?
Yes, so as I indicated, every year the board has taken up and will again take up next month the question of whether farmers can use XtendiMax according to the federal label. And the research that is submitted to EPA in support of the federal registration has been provided to the plant board, but the plant board, when it analyzes it, follows Regulation 7, and rather than looking carefully at the same, scientific evidence and data that the EPA relies on, the plant board has said, if you don't have support basically from researchers at the University of Arkansas, we're not going to allow use according to the federal label. And so it continues to be applied.
So counsel, when it takes up this issue every time, are you submitting research every time, sort of on this yearly basis?
We do during the, usually there's a request for rulemaking and then there's a comment period. And every time Monsanto has submitted comments and explained the extensive body of research that's been considered by EPA, Monsanto has provided its research to the plant board. They're getting ready to make another submission in connection with the upcoming.
So is your position that unless you have obtained the years, it takes years, I guess, of research from universities within Arkansas, you are harmed?
I'm suggesting that the preference for research based on who performs it rather than other factors is unconstitutional.
Well, and let me ask you this. So is XtendiMax being used in Arkansas at some times during the year? It's authorized.
Yes, it is.
So the issue is that it's not being used necessarily when a lot of farmers would want to use it. It's just, the plant board's limited. It's when it can be sprayed, correct?
It's varied year to year. The first year it was not allowed at all. The second year, I believe it was not allowed at all in crop. And then since then, there have been restrictions on the date, additional requirements with respect to buffers, in ways that make it very difficult for the farmers in Arkansas to make effective use of the product.
So using the unwritten rule, it was not allowed at all. But then when it switched to Regulation 7, it is allowed at some times and under certain conditions. So my question, I guess, is to what extent is they've authorized the use, just not particularly how you would like it, and it's open. So how is Regulation 7, that requirement, harming you in the sense that the research has authorized the use of the product in Arkansas? So they've accepted outside research.
Well, they have accepted outside research in just a very limited fashion. And so the restrictions that have been placed on the product make it very difficult for farmers to use it in a way that gives them the real benefit, which is the in-crop use during the growing season.
Well,
and so
I guess, though, my question is that if you're making the argument that the plant board is only going to consider research from within Arkansas, they clearly have accepted your research to a certain point because they've authorized its use at some times during the year.
Yes, I don't think we have to show that they don't consider any other research. The issue is, can they give primacy to research based on the fact that it was performed by people employed by the universities in Arkansas? So the question, is there a less restrictive or less burdensome option for the planning board? Of course there is. They could just say, we're going to require research that was conducted in Arkansas. That's totally non-discriminatory in terms of the economic interest of in-state and out-of-state researchers. And so because there is a non-discriminatory avenue available to the board to advance the same interest that it's asserting in Regulation 7, it has to choose that non-discriminatory option. And so that's what we're saying, is they can't be putting a thumb on the scale of research based on the fact that it was performed by people employed in the state. That's what the
doesn't Regulation 7 specifically say that the University of Arkansas research would only be used as guidance?
I believe it says that it will be the primary expertise considered by the board in making registration decisions.
And then it says, well, this expertise shall be used as guidance when considering a product for registration or restricted use. The board may consider other research sources and is not bound to the advice or findings of any one individual or entity.
Yes.
And it's left with the discretion of the board to determine how to weigh the various sources of input on the research.
Well, I don't know that it's completely within the board's discretion, because the regulation, and it's really one sentence there that we are objecting to. It says
continuation of the sentence that I just read said, "In any final determination regarding registration rests within the discretion of the board." That's the last sentence in this section of Regulation 7.
Yes, and I think the provisions that come before that limit what the board can and can't consider, or will and won't consider, or how it considers research when it exercises that discretion. And so the fact that it says research conducted by scientists from universities within the state will be the primary source of expertise, that is putting a thumb on the scale in favor of local economic interests.
So let me go to that argument for just a moment that you're making on the Commerce Clause to declare that there's some discriminatory in-state interest that would make it unconstitutional. I wouldn't disagree that that's kind of the general concept, but there are exceptions to that. I mean, there are exceptions that say that if the action serves a legitimate local purpose and the purpose could not be served as well by other available non-discriminatory means, it doesn't make it unconstitutional. It just has us apply a heightened scrutiny at that point. It moves it to a rigorous scrutiny review. So we have to look deeper into that purpose, and I think Regulation 7 addresses that by talking about the unique environment in Arkansas and things that are in play here. So I'm not sure. I'm not sure that even if we get to the merits of your claim on the Commerce Clause, that you prevail, that it's discriminatory to a level that would create an unconstitutional action.
You're exactly,
because I don't think you've really gotten down that road in the merits. I mean, we have U.S. Supreme Court case law, Philadelphia versus New Jersey. Differential treatment is permissible if it's supported by some reason apart from the origin, dealing with that in-state or out-of-state. I mean, it's not a rule without exception. It just requires a heightened review as to the purpose. Is that not accurate?
yes, I think you're exactly right. Where the statute or regulation discriminates or makes distinctions based on in-state and out-of-state interests, economic interests, the standard that applies is the law is still valid if the board could show here that it doesn't have another means of advancing its legitimate interest. And so you look at what's the interest that the board says it is advancing with the regulation. That's laid out in the board's brief. It is essentially to ensure that the research that pesticide registrants are submitting is actually relevant to the cropping conditions in the state of Arkansas. No dispute that that's a legitimate state interest. So if it has a legitimate interest, and here we concede it does, that's a legitimate interest, The question is, could they advance that interest in some way that would not burden out-of-state or interstate commerce? And I think I identified earlier, but there are two that are very easy. First, the board could say, we're going to require a showing that the research you've submitted is relevant to cropping conditions in Arkansas. So it could be performed in another state if you could show that that state had similar conditions as those that prevail in Arkansas. Or if that wasn't sufficient for the board could even say, we're going to make you perform research here in Arkansas, except that it wouldn't have to be performed by any particular people. So it could say.
And it appears that they've done that with Regulation 7. I mean, I feel like we're arguing what the old rule was versus what the new rule was and kind of ignoring what the language of the new rule is. I mean, it says certain things, and the things that it says seem to be in conflict with what you're arguing today, I think.
I think there's a real fine distinction here that's important. The question is, we would not object if the statute said, research conducted in Arkansas will be the primary source of expertise or the primary source relied on. We would not object.
That's the opening kind of shot across the bow here. The opening language of Regulation 7 says the board considers the environment in Arkansas to be unique. Therefore, there will be a higher consideration given to research that is specific to Arkansas.
Right. And then it goes on.
Monsanto has the ability to conduct Arkansas-specific research and present that to the board under the rule, under the plain text of the rule.
Right. And so I think you've made an excellent point that because that is already in the regulation, what work is being done by this additional sentence that says research conducted by scientists at the universities in the state are going to be given primacy, if you will. That means something in addition to what's already there. And it's that piece that we are objecting to. It creates this kind of cottage industry where registrants are incentivized to be funneling their research dollars specifically to researchers at universities in the state. And so I think that's the real rub. We're not objecting to a requirement that registrants submit data or scientific research that was conducted in the state or that was conducted under similar kinds of cropping conditions. That would advance the state's interest in a way that didn't burden interstate commerce. And because that option is available, the way the regulation is written now, it does violate the Commerce Clause.
Ms. Blackwell, I want to go back to what Justice Hudson first started off, and that is all we have for our analysis are the pleadings, and the circuit court made a decision based on the pleadings. Do you think it would have helped our analysis if you had had a hearing and some of these arguments that you're trying to develop before us had been pled in the trial court for our consideration? Otherwise, I think what Justice Hudson is saying is we don't have the facts necessary to consider what we believe might be just a facial challenge as opposed to as applied challenge.
I don't think so. So the board has argued actually that that this should be treated under the standard for facial challenges. And in fact, we've cited, I think, in our reply brief, a case from the U.S. Supreme Court that indicates that that standard doesn't apply when you're talking about Commerce Clause challenges. And for the Commerce Clause analysis, all you really need is to take a look at the regulation and see, does it benefit or burden in-state and out-of-state economic interests? If it does, then you have this question of, is there an alternative means for the state to advance a legitimate interest? So I don't think you need additional fact development because we're not disputing the legitimacy of the interest that was asserted by the board. And it's clear that there are alternatives that would advance the state's interests because the interest asserted is just that you have research relevant to the cropping conditions in the state.
And the product that you were referring to, Extendamax, I think Justice Wood asked you whether that was being used in Arkansas, and it is, but not at a particular time of the year. Is that correct?
That is correct. The board will consider again in a few days whether and how it will be used. during the 2021 growing season.
Yeah.
But last year was permitted in some more restricted fashion.
And so the plant board, excuse me, Ron, the plant board obviously has considered your research that has been presented to the other states for its approval here in Arkansas, correct?
Yes, but it has repeatedly relied on research conducted by University of Arkansas researchers, one in particular, in order to impose restrictions that are different from those imposed by the US EPA and different from those that are imposed by other states. And so, again, this is really we're talking about just kind of a legal challenge based on the wording of the regulation, but it does in fact have an impact day to day.
Thank you.
Counsel, I apologize, Justice Wynn. I didn't mean to interrupt your line of questioning. But counsel, I guess I know that Mr. Ballard talked a little bit about the other point, but are you at all concerned what the remedy is if you could be successful on one issue on appeal and not the other? If we find that the plant board as consists is unconstitutional and we vacate the majority of it, then you're sitting here primed to ask the board to, you said in May in front of it is to allow you more use of your product, and now you don't have a board that could consider that. So you've in a sense harmed your company and the farmers that are wanting to start using it.
I appreciate that question. I did want to address the de facto officer doctrine and how it applies here. So the second ground we've argued as a basis for invalidating Regulation 7 is that it was adopted by an unconstitutionally appointed plant board. And that, of course, then raises the issue of what would be the impact of a ruling like that. The board has suggested that Regulation 7 is protected by the de facto officer doctrine. The de facto officer doctrine clearly serves important interests. It serves the interest of stability in government, and it preserves or protects the reliance interests of those people who have relied on prior government actions in order to order their business. And so clearly the de facto officer doctrine protects important businesses. But what the courts have said is that you have to recognize that wholesale application of the doctrine implicates other interests that are equally important. And so one of those is allowing individuals who have been harmed or injured to have a remedy where standing requirements would have previously prevented them from making a challenge. And then second, there is a public interest in incentivizing private citizens to bring suits that challenge invalidly appointed boards or agencies. So if you just apply the de facto officer doctrine wholesale, there's no incentive for anybody to challenge, and there's no remedy for someone who is challenging it. So what the courts have said is, we got to balance those interests. And I think that's the hard job that this court will have as it looks at what's the impact of a ruling that the plant board was unconstitutionally appointed. And what the cases have said is that's really a case-by-case balancing. So in this case, you would balance what is the interest, sort of the interest of the people in Regulation 7. How much stability is there? How much are people relying on it? Is this really going to disrupt public reliance and public interest? Versus what's the remedy? Monsanto could not have sued before it was impacted by Regulation 7 to challenge the board's authority. It then has the harm, it has standing, now brings the challenge, and the answer is, sorry, there's still no remedy for you because of the de facto officer doctrine. And so the courts have suggested, this is the Andrade case that we've cited in our briefing. It says, here's a reasonable guide. If there are two factors that are, or two requirements that are satisfied, then an invalid act of the board could be invalidated. And those requirements are the individual, well, first of all, the first one is it needs to be a constitutional issue, not just a technical defect in the appointment. We've got that here. We're claiming a constitutional defect. But the second is the person challenging the act must have brought that challenge at or around the time of the action. And the board has to have had notice that that objection was being made to its authority at the time that it was at or around the time that it was taking that action. And so in this case, we have Monsanto. It gets subject to the unwritten rule and deprived of any use of its product in the state for an entire year, which was significant. And then it files a lawsuit. It challenges the board's authority. It challenges the unwritten rule.
Counsel, I'm going to cut you off because I think we're going way over on the time. So, but I think you've answered my question. So thank you.
Hey, Counsel, let me ask you a question in conjunction with the issue brought up by Justice Hudson. Paragraph 164 of your second amended complaint alleges that Monsanto's petition was denied at the September 21st, 2017 meeting. Paragraph 166 of that amended complaint also alleges that at that same September 17th, 2017 meeting, the plant board voted to approve the new version of Regulation 7. My question is, from your pleadings, was that action denying the petition taken after the vote of the board approving the new Regulation 7 or before approval? It doesn't appear to be clear in the pleadings, and I think that's what Justice Hudson's getting, points bringing out. We're a fact pleading state. This is a judgment on the pleadings. Where is it in the pleadings that the denial was after adoption of the new rules, Regulation 7?
I think I'm not exactly following the timeline. You're asking, did Monsanto challenge the board before it adopted?
Was Monsanto denied its petition before or after the adoption of the new Regulation 7? It's not clear from the pleadings that I can see.
And I think maybe my confusion is Monsanto's made multiple petitions to the board. So the timeline is 2016, the board voted under the unwritten rule not to allow use of the product. Then there are multiple rulemakings each year that Monsanto participated in. There's also a rulemaking for Regulation 7 that Monsanto submitted a written comment and objection to before it was approved by the board. And the filing of the complaint challenging the board's authority occurred before the adoption of Regulation 7, the written form of Regulation 7. So the board had noticed that its authority was being challenged by Monsanto at the time that it adopted that written rule.
Your second amended complaint supersedes your first amended complaint and original complaint, doesn't it?
I believe so, yes.
So that's the complaint that we're dealing with here before this court is the second amended complaint. And in that complaint, it's alleged that Monsanto was denied at the September 21st, 2017 meeting. And it's also alleged that the new version of Regulation 7 was adopted at that same September 21st, 2017 meeting. So my question, it's not clear from the pleadings whether the new version was adopted by the board before, and the board relied on that new version before the board denied Monsanto's petition, or whether they denied it under the unwritten rule previously that you're referring to. And that goes to the justiciable issue that Justice Hudson's pointed out. It's not clear in the pleadings. You've got to plead the facts, and this is a judgment on the pleadings.
Correct. And I think maybe I'm still not exactly following. You're asking if the petition to allow use of the product in the state was denied before or after?
Well, we know it was denied at that September 21st meeting.
Yes.
Was it denied? Was it denied on the basis of the previous rule or the new version of Regulation 7?
it's happened both ways. It was disallowed under the unwritten rule. Then Monsanto filed suit, Regulation 7 then was adopted. Its effective date is, I believe, May of 2018. Our written comment on Regulation 7 was submitted in December of 2017. So after Monsanto filed its complaint. Monsanto, then there have been rulemakings each year in which Monsanto petitioned for the plant board to allow use of the product according to the federal label. And those have continued to be denied each year after the adoption of Regulation 7.
But are we in this case dealing with the denial on September 17th, 2017? Isn't that what you alleged?
We've alleged multiple denials starting in the beginning, the end of 2016, going into the 2017 crop year, and then each year after that through 2018.
Any other questions?
Ms. Blackwell, on rebuttal, will you please bring to the court's attention the specific paragraphs in the second amended complaint that answers the Chief Justice's question?
The exact allegations in the second amended complaint that allege what exactly?
Actually, how Monsanto's real life interests in a case or controversy collide with Regulation 7. We will see you then.
Okay, thank you.
And the court will recognize counsel for the Arkansas State Plant Board. Ms. Merritt. Still on mute.
You're still on mute.
Okay.
Good morning, and may it please the court. My name is Jennifer Merritt. I'm a Senior Assistant Attorney General, and I represent the Plant Board and these two consolidated appeals for the purposes of oral argument. On the common issue before the court today regarding the constitutionality of the Plant Board's appointment statute, this court should affirm in McCarty and reverse in Monsanto because the statute does not clearly and unmistakably conflict with any provision of the state constitution. And on direct appeal in Monsanto, the court should affirm for multiple reasons, including failure to exhaust administrative remedies, lack of standing, ripeness, lack of subject matter jurisdiction, and failure to state a claim, either an as-applied challenge or a facial challenge. I'd like to start with a discussion regarding the constitutionality of the appointment statute. Of course, as with any statute, the court must start with the presumption of constitutionality. The court must uphold the statute unless Monsanto and the McCarty appellees or appellants meet their heavy burden of showing a very clear and unmistakable conflict with a provision of our state constitution. It's well established that our constitution is not a grant of enumerated powers to the legislature, but rather it is an express limitation of powers. It's a restraining document of the legislative power, subject only to the express limitations and restrictions therein. And what that means is that all of the legislature encompasses all of the powers that are not expressly or impliedly prohibited by the Constitution. As this court held in Cox versus State, the Arkansas Constitution is silent on the issue of which branch of government holds the appointment power. Well over a century ago, in that case, this court rejected the same argument that Monsanto and the McCarty farmers raise here. The court held that the power to appoint officers is a prerogative of the people, and it can be exercised by the legislature as they see fit, as long as they provide appropriate standards and guidelines when they delegate that authority. As the Cox Court held, quote, "The method of selecting the members of boards is a matter to be determined by the legislature," end quote. The people can only act through their duly elected representatives in the legislature. And in this particular instance, the legislature adopted this particular appointment process back in 1917. And this is how the plant board has operated since that time as a matter of public policy. Because there's no provision of the Arkansas Constitution that limits the legislature's power to delegate that authority, the court must uphold the statute. All doubts under this court's precedent must be resolved in favor of upholding the statute. And on direct appeal, the court should uphold Regulation 7 as well for multiple reasons. First of all, these claims are procedurally barred. Monsanto did not allege any facts in its second amended complaint, which the court has recognized as the operative complaint here, showing that it's exhausted its administrative remedies on the issue of the constitutionality of Regulation 7. Monsanto's counsel here today said that it submitted some public comments on Regulation 7, but there are no facts alleged in the complaint showing the court that it ever challenged, raised a Commerce Clause challenge to Regulation 7 before the plant board. And this court's precedent is very clear that a party must raise challenges to a regulation, even constitutional challenges before the agency, before they're allowed to come to court and seek a judicial remedy and a review of that issue. And absent such allegations in Monsanto's operative complaint, its claims are procedurally barred. Second, Monsanto lacks standing to challenge Regulation 7. The court reads the operative complaint. Monsanto couches its claims in terms of the out-of-state researchers that are allegedly burdened by the regulation. But of course, Monsanto does not have standing to raise claims of unnamed third parties, nor does Monsanto have standing to raise claims for injuries that are speculative, for injuries that haven't happened yet. There are not any allegations in the second amended complaint that Monsanto ever applied to register its XtendiMax product after the adoption of Regulation 7. All of its allegations are backward looking. Yes, Justice Squid.
Counsel, from the very start of their second amended complaint, they even reference they reference that even the May of 19 decision of the board. So why is it not a continuing injury to them? I mean, if you start with their complaint, you know, on the first page, in the second page, they talk about the 2017 session. They talk about 2018, which would have been after Reg 7. They talk about in March 19 that the board made another, adopted another rule limiting the use of their product. So why is this not a continuing injury that they're alleging would give them standing?
You have to allege actual facts under our fact pleading rules, and the whole issue of this particular product, as we pointed out in a footnote, this product lost its federal registration. A pesticide cannot be used in Arkansas unless it has a valid federal registration first, and then a pesticide manufacturer has to also obtain state registration for this in-crop use that Monsanto seeks in this particular case. And in this case, Monsanto lost its federal registration. The Ninth Circuit stripped its registration last year, and it didn't regain its federal registration until November 5th of 2020. And since November 5th of 2020, Monsanto has only applied to regain its state registrations in North Carolina, Tennessee, Georgia, and Texas. That's public information on the EPA's website.
Counsel, is that in the record? Have you asked us to take notice of that?
It is not in the record. It's a matter of public record that the court could take judicial notice of on EPA's website, and there are not any allegations of Monsanto's complaint about that issue.
But counsel, did they have was it valid in 2018 under Reg 7 when they were, it again put another ban on the crop year, when the plant board passed another ban?
I think in May of 2018, when this regulation went into effect, I don't believe it was a ban. The plant board allowed in crop use of dicamba pesticides, but not Monsanto's specific product, because Monsanto did not submit an application with any research. Monsanto chose not to participate in the process and has not submitted an application since Regulation 7 has been in effect. And there aren't any factual allegations in the complaint to show that Monsanto has suffered an actual concrete injury from the application of Regulation 7.
Counsel, under the United States Supreme Court's interpretation of the Dormant Commerce Clause, do you have to show an injury to bring a valid challenge?
Well, this is a state law claim that they filed not under Section 1983. They have filed this claim under the State Administrative Procedures Act, the State Declaratory Judgment, and this court.
Counsel, that wasn't my question. So my question is, under a U.S. Dormant Commerce Clause challenge, do you have to show an injury?
I mean, I think you absolutely, you have to have an injury to have standing to come to court. You cannot come to court absent an injury.
Counsel, are you certain of that? Do you feel comfortable that the U.S. Supreme Court has said that you have to plead that you've already been injured?
No, thank you, Justice Wade. I think if you have a certainly impending injury, that might be a different situation. But in this particular instance, Monsanto's injury is not certainly impending.
Well, and that was my question, because I think the Supreme Court has been pretty clear that you don't have to prove you've already been injured and to bring a Commerce Clause action.
Assuming that you otherwise have preserved your claim, you've raised it before the agency and those kinds of things, which are fundamental procedural bars here. So if the court were to reach the merits, but also there is no, in this particular case, Monsanto has those procedural bars. The court needs to look at Monsanto's complaint, see what jurisdictional statutes Monsanto cited for its lawsuit. It cited 3 statutes: Arkansas Code Annotated Section 20-1, which is a means to obtain judicial review of an adverse action by the plant board. But its second amended complaint does not allege that the plant board took any adverse action against it under Regulation 7, so that statute does not apply. Second, Monsanto cites Arkansas Code Annotated Section 25-15-214. But as this court ruled in Naturalis Health, that rule only allows an injured party to seek a court order commanding an agency to act in a case of rulemaking or adjudication if an agency unlawfully, unreasonably, or capriciously fails or refuses or delays to act. But again, the second amended complaint does not allege that Monsanto has been injured in any way yet by Regulation 7. And also, this is not a case of rulemaking or adjudication. So Section 214 does not apply under this court's precedent. Finally, Monsanto cites Section 207 of the APA, which is the declaratory judgment provision. But in Naturalis Health, this court held that Section 207 only confers subject matter jurisdiction on a circuit court to resolve the validity of an agency rule if that rule or its threatened application injures or threatens to injure the plaintiff if in its person, in its business, or in its property. But the lack of an actual or an imminent injury to Monsanto here serves as a jurisdictional bar to its claims in this court in this case. Also in Naturalis Health, and it's a related concept, but it's the concept of rightness. In Naturalis Health, the court squarely held that, quote, arguments concerning the denial of a medical marijuana cultivation facility license were not right for the circuit court to hear, end quote, because the appellees in that case had not been issued a denial letter subsequent to an adjudication.
But counsel, again, I think Ms. Blackwell was talking about that there's a difference between an as-applied and a facial challenge. And can we speak to the, I guess because we've drifted into that, the Dormant Commerce Clause, Because if it's facially discriminatory, then you have to show whether or not you could have achieved your results through something different, and that's what they're alleging. And so I guess tell me why this isn't facially discriminatory, because when I read it, if I substitute something else for those words, it appears facially discriminatory. If I said, if I was a university and I said, I'm primarily going to accept male applicants, but I'll consider women, we would say that was facially discriminatory. Or if I said that with regard to any other category. So why isn't it saying we primarily consider research by scientists at our universities, but we'll look other places? Why isn't that? Tell me why that's not so.
Well, it's not discriminatory because it does not require research from within the state of Arkansas or by researchers within the state of Arkansas or from our universities.
Well, counsel, if it said we primarily rely on male researchers, would that be discriminatory?
It's not facially discriminatory because it's not.
Well, that was my question.
In every application.
Would you agree that if it said we primarily rely on males researchers, that would be discriminatory?
It would not be facially discriminatory, Justice Wood, because the test there is whether, under our court's precedent, whether the regulation is discriminatory in every single case. And
so
because
if it said we primarily rely on male researchers, you're telling me that would not be discriminatory?
Justice Wood, it's a different situation.
Okay, you know what? If you're not going to answer my question, you can move on.
It's not facially discriminatory under the court's precedent because the test is whether a regulation is discriminatory in all of its applications. And this regulation does not.
I understand. It would be nice if you answered the question sometimes.
My answer is no, it would not be facially discriminatory. This regulation says that this expertise shall be used as guidance when considering a product. So it does not require Arkansas-based research, nor does it require research by Arkansas researchers. So it's not a requirement at all. It's simply guidance. And it also says very clearly that the board may consider other research sources and is not bound by the advice or findings of any one individual or entity. And any final determination regarding registration rests within the discretion of the board. So this regulation does not require anything within the state of Arkansas. It does not bar or keep anyone from the market. So it's very unlike all the precedents that are cited by Monsanto. And so it's not facially invalid. There are circumstances. I've learned, I wish that there were facts in the record about this. I won't share it, but this hasn't come up before because most of the time folks do submit their tests or their products for pre-market testing by state researchers for free. So it's not an issue. This hasn't come up, but it's not invalid as applied. But even if the court were to disagree with me on the constitutionality of the statute or the regulation under the Dormant Commerce Clause, the court should still uphold the regulation under the de facto officer doctrine. That doctrine clearly says that a de facto officer is anyone who has a colorable claim to a public office, even if there is some legal defect with the appointment later, that the court later finds there was a problem, even if it's a constitutional problem. Under Arkansas state law, Monsanto cannot challenge the acts of de facto officers as a matter of law, and that's the Brown case. In Brown, this court explained that acts of an officer de facto are valid and effectual as to third parties, such as Monsanto, as in this case. And the court reached a similar result in the Forest City Grocer Company versus Catlin case. It will make sense so that our state can function regardless of technical defects in the appointment of public officers. The United States Supreme Court has also recognized that even constitutional defects do not serve to invalidate the acts of an officer de facto. That was Buckley versus Vallejo, as well as Connor versus Williams. And the one case that the Monsanto appellant points to as distinguishable, because in that particular case, the party challenged the de facto officer's authority before the officer made a decision on his particular case. So the officer was not acting in a de facto capacity when they reached the decision that's being challenged. In this case, Monsanto did not challenge the board's authority to adopt Regulation 7 on this basis at the time. Monsanto only challenged the board's authority to adopt Regulation 7 separately in a lawsuit. So the de facto officer doctrine saves Regulation 7. And unless the court has additional questions, I'll yield the rest of my time. Thank you.
Counsel, I have a question.
Yes.
A couple actually. Can you, on the de facto officer doctrine, can you kind of give the state's position? We heard from Mr. Ballard about the kind of the Wild West example. If we were to find that the members of the board were not constitutionally appointed, kind of help us define from the state's perspective what the scope of that type of decision would be in terms of how that would impact other actions taken by the plant board.
I have to agree. It appears that there would not be a quorum. Okay, in the Monsanto case, the court only struck the specific subsections of the statute that had the private appointments, but even the public appointments by the governor are not enough for a quorum. And so I think that leaves us without a plant board that can act. And that's a situation we just absolutely can't have in Arkansas. The plant board serves vital functions, protecting public health, protecting our water supply. It's a vital health and safety function under the Pesticide Act. The de facto officer doctrine serves an important, vital for purpose, and the court should absolutely apply it here for that reason.
Okay, the other question I have is on Act 361. Did your office, was that like part of your office's package for the legislature this year, or was that something you guys pursued?
I don't know anything about that. I only found out that was passed after the fact, Your Honor. I'm not certain.
All right, my question was going to go as to why, with this issue pending out there, there wasn't an emergency clause to get this issue resolved instead of leaving it hanging for several months. But you may not have that information, so thank you.
I don't. I'm sorry, Your Honor.
And I have a question, Counselor. How does your position square with, and I realize the Attorney General opinions are not controlling authority for this point or anyone else, but there's an opinion that was issued in 2005 by the Attorney General that basically takes a contrary position that you're taking in this case as far as allowing private organizations to be appointed to serve on public boards.
Justice Webb, you're cut out just a little bit, but I believe you were asking a question about a 2005 Attorney General opinion where the Attorney General came out a different way. And the answer to that, Justice Webb, is real simple. It's because the statute that the Attorney General was offering the opinion on in that case did not have a delegation of the appointment authority to any private individuals. That statute only delegated appointment authority to certain folks. And the Attorney General said, look, I have to construe, or the court will construe a statute according to its plain and unambiguous terms. Those are the rules of construction. And because the legislature delegated authority to folks 1, 2, and 3, that's it. You cannot delegate your authority to anybody else. Furthermore, in that case, I think it had to do with a sewer improvement district. They had bylaws that also limited the appointment authority to the same entities that were playing the statute. So the Attorney General simply interpreted that particular statute in accordance with its plain terms. This statute is completely different. The legislature made a policy choice and did delegate appointment authority to private groups. So it's a completely different statute in that opinion. And to the extent it applies at all, Justice Webb supports our position. Unless there are further questions, I'll yield my time if there is any. Thank you.
A rebuttal for McCarty appellants.
May it please the court, Grant Ballard on behalf of the McCarty appellants again. I think that I would point out for the court that I have a fundamental disagreement with the state in regard to the limits that the Arkansas Constitution places on the delegation of public appointment power. I believe Article 5 clearly states that legislative power should be vested in the General Assembly, I think you can go back to the Cox v. State case, and our Supreme Court stated that included in the legislative power is the power of appointment. And I don't want to overlook the fact that we have a line of cases in this state from our Supreme Court that support my client's, the appellant's position that legislative power cannot be delegated to private business interests or private business associations. That line of cases does start with Cox in 1904. But as far back as the 1950s, the Supreme Court said that municipalities, cities could not appoint legislative rulemaking power to private committees. That's the City of Harrison versus Snyder case. Specifically says legislative functions cannot be delegated, whereas ministerial functions may be delegated. More recently, in the late 90s, you have the Letters v. Gulf Rice, Arkansas case. In that case, the Arkansas Supreme Court specifically recognized a doctrine prohibiting delegation of legislative power. In that case, the statute that allowed private individuals to elect to effect an assessment on rice fires was determined to be an unconstitutional delegation of legislative taxing authority. So I think we have a good line of Arkansas cases that supports the appellant's position. And certainly there is no Arkansas case that says the legislature can delegate its appointment power to a private interest. Now, I know the state has argued in the pleadings that there's been some kind of legislative cure in Arkansas Code 10-3-309, but there's no requirement that any rule by this plant board be approved by the legislature or the governor. And in fact, subsection I of the legislative review statute states that approval of a rule under that section shall not be construed to represent that the rule is consistent with legislative intent. That's exactly what the state has asked this court to do in its pleadings, is to basically say that the approval of rules is a reflection of legislative intent or ratification. The statute itself says that is not the case. So I will restate the position that the case law in Arkansas has never been supportive of legislative delegation of appointment power to private individuals. Of course, there is case law that says the legislature can delegate some of its authority with adequate boundaries to other state agencies, but that is simply not the case we have here. I think everybody's aware of that. And finally, on the de facto officer doctrine again, I think that I would suggest that the court recognize that de facto officer doctrine under state law applies to collateral attacks, such as when someone charged with a crime tries to attack the prosecutor's position or authority to bring charges. That's a collateral attack. It's defined in the cases we've cited to the court. And I would suggest that we shouldn't allow, or this court should not allow, unconstitutional actions simply to save the General Assembly some work. They've got a problem, they need to fix it. I'll stand open for questions or yield the floor. Thank you.
Order to recognize rebuttal for Monsanto appellate. Ms. Blackwell.
Thank you, Your Honor. I'd like to first start by addressing the questions raised by Justice Hudson and Wynn with respect to the allegations in the second amended complaint. Paragraph 3, this is with respect to whether the Plan Board has made adverse actions with respect to XtendiMax after adoption of Regulation 7. It says in March of 2019, the Plan Board adopted yet another new rule for dicamba, banning the in-crop use of dicamba herbicides from May 26th through October 31st of each year, and imposing other restrictions on their use within the state. And then in paragraphs 179 and 180, this is with respect to the ongoing impact on Monsanto of Regulation 7. We've alleged in paragraph 179 that Regulation 7 effectively renders useless registrants, that would be Monsanto's, hiring of researchers from universities or research laboratories in other states to conduct the research needed to gain approval for use of their pesticides within the state of Arkansas. And then in paragraph 180, that Regulation 7 also burdens out-of-state registrants in a way that it does not burden in-state registrants, because it effectively deprives those out-of-state registrants of the opportunity to work with researchers in their home states and universities in their home states, where they may be able to secure quality research more economically. And so those are particular allegations with respect to the effects on Monsanto of Regulation 7. I also would like to address
Ms. Blackwell, Ms. Blackwell, going back to paragraph 3 that you brought to the court's attention, this again addresses the window within which the herbicide may be used, and so it's not a ban. It's a permissive use within a set of guidelines and boundaries that the plant board has determined. So I think Justice Wood hit upon this earlier. This really isn't saying to Monsanto that we aren't accepting you or your research. It's just we are accepting it, and we're putting boundaries in terms of how we use it in our state. How do you respond?
So pesticide registrants first have to obtain federal registration at EPA. And so to do that, they conduct research, usually in a variety of states, in order to get EPA approval for the federal registration. And that's the first step. They spend a lot of money on those studies and get them performed, in various locations to try to cover the relevant areas where the product might be used. You then go to the states and ask for registration in the state. What's happened here is Monsanto got the federal registration. The EPA approved a particular label that allows the product to be used in various ways. When we got to Arkansas, the first answer was, we're just not going to let anyone in the state use your product at all. The next answer the next year was, we're going to put restrictions on that federal label because you don't have research from Arkansas. And so,
Blackwell, it seems to me that Monsanto would like for our plant board in Arkansas to adopt the EPA standard. And from what I can tell, it looks like that premise is embodied in language that's out for comment right now. Is that true?
what I would say is states certainly do impose additional restrictions in some instances. The only place where we are here in court challenging those restrictions is Arkansas. And the reason is because Arkansas is the only state that says you have to have research from our state. And so when you look at the Commerce Clause balancing, courts will look at what would be the effect if every state adopted that regulation.
Right, but what's wrong? I mean, what are you upset about? Are you upset about the window limitation?
There are a variety of different things. In some cases, I think counsel for the board suggested that the window did permit in-crop use. In 2018, that's not true. So farmers are not allowed. The real benefit of this technology is that Monsanto has developed dicamba-tolerant crops, and you can apply this herbicide over the top of them while they're growing. There's a real pigweed problem in Arkansas, and this is an answer to it. Farmers in the state lose millions of dollars annually because they can't control pigweed. This is an answer to that problem, but if they can't use it in crop, it's no answer. And so farmers in the state of Arkansas are left at a disadvantage in competing nationally with other states in terms of the crops that they grow. And so those date restrictions are critical.
On behalf of the farmers of Arkansas?
I'm here on behalf of a company that helps them succeed.
Council, are there other companies' products that treat this that are allowed to be used during this period, but your product is not? So in other words, is it an issue of your products not being allowed during this, but other companies' products are allowed in?
For 2017, that was the case. The board permitted use of similar product, dicamba herbicide, that could be used over the top, that's manufactured by BASF, called
And that
Ingenia.
Pre-Regulation 7, true?
That's during the
Right.
unwritten rule. Yes. Now, interestingly, the board allowed the use of Ingenia in 2017 without BASF submitting 2 years of Arkansas research. But it enforced that requirement as to Monsanto to prohibit use of XtendiMax in 2017. Moving forward, the restrictions on the use of the in-crop dicamba products has been applicable to all of the registrants. So not just Monsanto's product, but also BASF's.
You cannot point to a disparity that Justice Wood is asking for between you and BASF or, you know, another entity.
Since Regulation 7.
Regulation 7 in terms of a kind of herbicide product generally.
I believe that's correct. I believe the restrictions after the adoption of the written rule, I believe the restrictions have been applied to all low volatility dicamba herbicides.
And that's what I've been asking for you to show me in the second amended complaint, in a paragraph, where is it that would make that allegation that under Regulation 7, Monsanto has been treated in such a way that, that it's different, there's a disparity, or some kind of factual allegation to show what the problem is that we are supposed to fix for you today.
I'm not suggesting that there's a difference in treatment across registrants.
Right, well, I mean, what's the problem?
Yeah,
What?
No, the issue is just the requirement that we be spending research dollars in the state with researchers who are employed by the University of Arkansas. It's not that we think they're bad researchers. Monsanto does, in fact, frequently do research with researchers from the University of Arkansas. But in some instances, it wants to do research in different jurisdictions, different locations, to support the federal registration, which applies generally across the United States. And so this separate requirement requires duplication of effort and requires that dollars be spent in Arkansas when they otherwise might not have been. So that's really the burden on the company that we're talking about going forward. Unless there's further question on that, I would just want to say something about the de facto officer doctrine.
What is our time limit right now? Where are we?
The court will give you 1 minute because we did ask you some questions, so you'll have 1 minute to address that issue in rebuttal.
Thank you, Your Honor. With respect to the de facto officer doctrine, I would just suggest the board can continue to regulate. If this court invalidates the appointments under the Constitution, the board will continue to regulate until they are replaced by constitutionally appointed board members. After that happens, people may come to the court and say, this particular regulation was not valid because it was adopted by an unconstitutionally appointed board. In that case, if that happens, the court would have to apply those interests and balance those interests that are protected under the de facto officer doctrine and make a decision case by case as to whether the de facto officer doctrine actually protects those actions that were taken by the board until they were replaced or not. So it's not a situation where you have the wild, wild west. Things will continue to function. There may be some challenges based on the unconstitutionality of the appointments, but that will be an issue for the court to address and decide under that balancing test with respect to the de facto officer doctrine. With respect to Regulation 7, that balancing test suggests that the invalidity of the appointments is an equal to the Commerce Clause, equal ground for invalidating Regulation 7.
Okay, that concludes your time, Ms. Blackwell. Any additional questions? Okay, if not, that concludes our oral argument this morning. Thank you, counselors. Since we've run over our anticipated time, let's plan on taking a 15-minute recess before we meet to conference these cases. And we'll attempt to conference these by the original Zoom invitation that I sent out to everyone. Hopefully we'll be able to get on that link. So at this time, then, court will be adjourned. Thank you.